$750. That's all he needed. A small loan to get through a tight spot, the kind of financial hiccup that millions of Americans face every single year. But when he finally sat down and read the documents after everything had already gone through, the number staring back at him wasn't $750. It wasn't even $1,000. The total repayment amount on that loan was over $5,600. For $750 borrowed. That is not a typo. And today, we are breaking down exactly how this happened, whether there is any legal way out, and what every single person watching this needs to know before they ever consider a short-term loan. So let's set the scene here, because context matters a lot in a situation like this. We're talking about a couple living in Princess Anne, Maryland. He works a full-time job making $19.25 an hour, picks up overtime regularly, and gets paid weekly. By most reasonable standards, he's a working guy doing what he's supposed to do, holding down a job, trying to keep his finances together. But life has a way of throwing curveballs, and at some point, he and his girlfriend found themselves in a financial bind that needed a fast solution. Now, the details of why they needed the money aren't really the point here. The point is that they needed it, it was urgent, and they started looking for options. And when you're in that situation, stressed, time-pressured, desperate for relief, you are exactly the kind of person that certain lenders are specifically designed to target. Not help, target. That distinction is going to become very important as we move through this story. He applied for a small personal loan and got approved for $750. And here's where things start to go sideways almost immediately. The approval didn't happen through a carefully reviewed written application where he had time to read everything. It happened over the phone. A real live person on the other end of the line talked him through it, created a sense of urgency, and made the whole thing sound completely manageable. According to what his girlfriend shared, the loan officer, or whoever was on that call, told him it would take around 4 to 5 months to pay off. 4 to 5 months. That sounds reasonable, right? If you borrow $750 and pay it back over 4 to 5 months, even with some interest, you're probably expecting to pay back maybe $800, maybe $900, $1,000 at the absolute most. That's what your brain does with information like that. It fills in the gaps based on what sounds logical. And nobody on that call corrected that assumption. Nobody said, by the way, the total repayment is going to be $5,600. Nobody mentioned the APR at all. After everything went through, after the money was deposited and the agreement was signed, they actually sat down and looked at the loan documents. And that's when reality hit them like a freight train. The APR on this loan is over 700%. 700%. And the loan is structured so that in the early payments, almost everything goes toward interest and almost nothing goes toward the actual principal balance. So even if he's making payments consistently, the balance barely moves at first. It's like trying to empty a bathtub while the faucet is running at full blast. Now, before we talk about what options they might have, we need to talk about what kind of loan this actually is. Because this is not some fringe illegal product being sold out of a back alley. This type of lending, often called a high-rate installment loan or a predatory consumer loan, is unfortunately legal in many states, and it thrives in a very specific way. It targets people who don't qualify for traditional bank loans, offers fast approvals with minimal paperwork, and buries the most important financial details in fine print, or simply doesn't volunteer them during the sales call. 700% APR sounds insane, and it is. But lenders who operate this way have lobbied hard in many states to keep these products legal. Maryland, however, is actually one of the states with stronger consumer protection laws when it comes to lending. Maryland caps interest rates on most consumer loans, and there are specific rules about disclosure requirements. This is actually a critical detail for this couple, and it may be one of the most important things working in their favor. Here's what the law generally says when it comes to loan disclosures. Under the Federal Truth in Lending Act, also known as TILA, lenders are required to clearly disclose the APR, the total amount you'll be paying back, the payment schedule, and all finance charges before you agree to the loan. These disclosures have to be clear and conspicuous. They cannot be hidden in footnotes, they cannot be mumbled at the end of a phone call, and they absolutely cannot be skipped entirely. If a lender fails to properly disclose the APR and total repayment cost before the borrower agrees, that is a potential violation of federal law. Now, did that happen here? Based on what this couple describes, no mention of the APR on the call, no clear breakdown of total repayment, just "you're approved, let's move forward." There is at least a serious question worth investigating. The pressure tactics, the vague language about a 4 to 5 month payoff, the complete absence of any discussion about how much the loan would actually cost. All of that paints a picture that a consumer protection attorney would want to look at very carefully. Maryland also has its own state-level consumer protection laws, and the Maryland Consumer Loan Law sets specific caps on interest rates that lenders must comply with. If this lender is not licensed in Maryland, or if the rate on this loan exceeds what Maryland law permits, the entire loan agreement could potentially be unenforceable or subject to serious legal challenge. Some tribal lenders and online lenders try to get around state interest rate caps by claiming they're operating under tribal sovereignty or the laws of a different state. But Maryland courts and regulators have pushed back hard on some of those arrangements. So, what should this couple actually do right now? The first and most important step is to stop panicking and start documenting everything. Every email, every text message, the loan agreement itself, any recordings if they exist, notes about what was said on the phone call and when. This paper trail is going to matter if they pursue any kind of formal complaint or legal action. Second, they should file a complaint with the Maryland Office of the Commissioner of Financial Regulation. This is the state agency that oversees consumer lending in Maryland, and they take complaints about unlicensed lenders and disclosure violations seriously. Filing a complaint costs nothing and puts the lender on the regulatory radar. Third, and this is huge, they need to consult with a consumer protection attorney, ideally one who handles predatory lending cases. Many of these attorneys work on contingency, meaning they don't charge you up front. They get paid if they win. Organizations like the National Consumer Law Center can help connect people with attorneys who specialize in exactly this type of situation. Maryland Legal Aid is another resource worth contacting immediately. Fourth, they should look up whether this lender is actually licensed to operate in Maryland. If they're not, and some of these high-rate online lenders are operating in a legal gray area, that fact alone could be the foundation of a very strong case. Now, here's the broader lesson that everyone watching this needs to hear, because this story is not unique. This happens thousands of times every single day across the United States. Predatory lenders have spent decades perfecting the art of making exploitative loan products sound reasonable over the phone. They know that when you're stressed and you need money fast, your critical thinking is compromised. They know that most people won't read the fine print until it's too late. And they know that the shame and confusion that follow can keep borrowers from ever fighting back. But here's what you need to remember. If you are ever in a situation where you need to borrow money quickly, there are questions you must ask before you agree to anything. Ask for the APR in writing. Ask for the total repayment amount in writing. Ask how the payment structure works and how much of each payment goes to principal versus interest. If anyone on a phone call hedges on these questions, gives you vague answers, or rushes you through, hang up. That behavior itself is a warning sign. And if you have already signed a loan that you believe was misrepresented to you, whether that means the APR was never disclosed, the total cost was never made clear, or the sales process felt pressured and deceptive, do not assume you have no options. Federal and state consumer protection laws exist specifically for situations like this. The fact that you signed a document does not automatically mean the document is enforceable if it was obtained through deceptive practices. This couple in Maryland is not out of options. They are scared and overwhelmed right now, but they have real legal avenues to explore. They live in a state with meaningful consumer protections, and the behavior they're describing on that phone call raises serious red flags under federal disclosure law. What they do next matters enormously, and hopefully this breakdown gives them and you a clearer picture of where to start. If this happened to you or someone you know, a loan that seemed reasonable until you read the fine print, a lender who never mentioned the APR, a repayment amount that left you feeling completely blindsided, the most important thing you can do is talk to a consumer protection attorney and contact your state's financial regulatory office before you do anything else. You may have more rights than you think. And if you want more content like this, real stories, real legal breakdowns, real answers to the questions people are actually asking, make sure you subscribe. We cover situations like this every week, so you know your rights before you ever need to use them.